Hello everyone, and thank you for tuning in. I'm Shairan, and you're watching Law Around the World. Today's discussion is rooted firmly under the pre-contractual duty of disclosing material facts in both the Law of Contract of England and Wales as well as Malaysia. But before I call upon our guests to help facilitate this discussion, I would like to help brief our audience regarding the topic at hand. The question of when a contracting party is in possession of valuable information unknown to the other generally has the right to remain silent and profit from it has fascinated scholars in philosophy, law, and history since ancient times. The general rule in both English and Malaysian law of contract in regards to pre-contractual duty to disclose material facts states that there is no general duty to either party to disclose material facts to the other at or before the time of making a contract. However, before we delve into the meticulous details of both the general rule and its exceptions, allow us to embark on a brief historical journey as to the emergence of the duty to disclose material facts. The roots of the duty to disclose material facts to contracting parties can be traced back to the law of merchants, known as the Lex Mercatoria, which was borrowed by common law in managing trade and then under the development of English commercial law. Ultimately, in 1756, the Chief Justice of the King, Lord Mansfield, incorporated the duty to disclose material facts into the law of contract through the groundbreaking case of Carter and Bowen. Despite such an influential judgment, the general rule has prevailed over common law, which was adopted into the Malaysian law of contract, as the Malaysian legal regime has been highly influenced and modeled after the English legal principles. To further add on, the courts of England and Wales, as well as Malaysia, have applied the test of materiality as to uphold the general rule. A material fact can be defined as an aspect which may induce a reasonable person into a contract. This definition has become the base of the test of materiality, which comprises of two major limbs. The first limb is an objective test which requires full disclosure of information that is deemed influential. The second limb substantiates the first limb by requiring evidence of said influentialness by proving the elements of inducement. Allow me to introduce our guests for today. First, we have Professor Rachel from the University of Cambridge. We have Ms. Hira, solicitor from Nelson Murdoch, and Mr. Nakul, prominent legal jurist. Welcome to our show. And now let us begin with you, Professor Rachel. Could you please share some insight regarding the pre-contractual duty of disclosing material facts in the law of contract of both England and Wales as well as Malaysia?
Law governing the pre-contractual duty to disclose material facts is similar in both English and Malaysian law of contract. However, to simplify, I will be looking into both jurisdictions independently. In the United Kingdom, as a general rule, a person who is about to enter into a contract is under no duty to disclose material facts known to him, but not the other party as illustrated in Keats and Callaghan. The law must be careful not to run ahead of popular morality by imposing duty to disclose material facts in every trivial negotiation. And the contracting parties have to absorb responsibilities while entering a contract, which forms the basis of the doctrine of caveat emptor. This perennial doctrine lays the foundation for the general rule in the law of contract of England and Wales. Under caveat emptor, burden is squarely placed on the purchaser to discover matters affecting the satisfaction derived from the outcome of the contract, which is simply explained as let the buyers beware. In the UK, since the sellers are generally not obligated to disclose any information to the buyers and the solicitors have the duty to, apart from the usual conveyancing searches, inquire in depth on the seller's solicitors. This is seen common in the UK as it is an extra step that the buyer's solicitors go through to protect their clients due to the existence of the general rule. This is regarded as an inquisitorial and defensive approach to information that is actually readily available to the seller by the UK law society. What if there was a gruesome murder in a property? Does the seller have a duty to disclose such a horrific past to the buyers? Surprisingly, in the UK, the same rule also applies if there is a history of murder in a property that the seller did not disclose to the buyer during negotiations, as evident in Sykes and Taylor laws. When Judge Nyland decided to uphold the general rule even if it is morally wrong to do so. This further substantiates the rule propounded by Viscount Malcolm, where he stated that mere silence, however morally wrong, will not support an action of deceit. In a nutshell, such ruling affirmed that no party generally has a duty to disclose material facts at or before entering a contract. As for the Malaysian position, the law of contract is governed under the Contracts Act 1950 before delving into the general rule. Under Section 10, subsection 1 of the Contracts Act 1950, an agreement is a contract only if it is made by free consent of the parties. Consent is said to be free when it is not caused by fraud or misrepresentation, as seen under Section 40, subsection C and D of the Contracts Act 1950. Even though the Contracts Act does not define the duty to disclose material facts, it impliedly affirms the general rule, which is practiced under the English law of contract with regards to disclosure of information. This can be clearly seen under the illustration A of Section 17. The explanation to Section 17 of the Contracts Act 1950 does provide the same principle mentioned by Viscount Malcolm. The aforesaid provision explicitly states mere silence is not fraud, which affirms the existence of the general rule in the Malaysian law of contract. We pay attention to illustration B of Section 17. It clearly explains the general rule when traders are not bound to share private information at or before the signing of the contract. It's also vital to note that the caveat emptor rule also applies in Malaysia, as it is seen in the Sale of Goods Act 1957 and affirmed in the exception to Section 19 of the Contracts Act 1950. It states clearly that if consent was caused by misrepresentation under Section 18 or by sudden fraudulent misrepresentation within the meaning of Section 17, the contract is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. In Lau Hipia and Highfield Engineering, the court stated that there is no active duty on the part of the seller to disclose material facts to the other party pre-contractually. Additionally, in Karupanan Chalapan and Chong Li Chin, the court held that if a party has means to find the truth by ordinary diligence, then the contract is not voidable, which further substantiates the general rule. Another public question is whether the same principle would apply if the agent is acting on behalf of the seller. In the case of Lau Ki Ko and Paul Ni Siu, the federal court decided that an agent does not have any duty to disclose material facts as he is acting upon the party of the contract. With all that said, the general rule in both the United Kingdom and Malaysia has no general pre-contractual obligation between the contractual parties to disclose material facts.
Thank you, Professor. While the general rule, as mentioned by Professor Rachel, in the English and Malaysian law of contract still holds true today, there are certain exceptions to said rule. The first exception under the English law of contract comes in the form of active concealment of material facts. Active concealment of goods to be sold can amount to misrepresentation under English law. A case that comes to mind is the case of Schneider and Heath, in which Chief Justice Manfield stated that there was fraudulent misrepresentation as the defendant made a conscious effort to hide a defect from the buyer. This implies that a party has a duty to disclose material facts to the other, as failure to do so could amount to misrepresentation. However, the case of Horsfall and Thomas outlined that even with the presence of active concealment of material facts, the contract can only be rescinded if said fact was the reason for inducement into the contract. The second exception to the general rule in the law of contract of England and Wales is the suppression of material facts, namely if it can render a true statement false and amount to misrepresentation as seen in Dimmock and Hallett. This also holds true to partial non-disclosure as evidenced by Peake and Gurney. As such, it may seem like the only viable option in forging a contract is to disclose any and all information, as anything less may amount to a misrepresentation. This is further propounded by the notion that even literally true statements may be misleading if the maker does not disclose all relevant information, thus serving as an exception to the general rule. The third exception is what is often referred to as snatching up a bargain. In other words, a claimant will be prevented from snatching up a bargain which he knew was not intended by the defendant. Smith & Hughes has established that a seller is under duty to disclose the existence of a mistake on the part of the buyer, but only if the mistake itself is important to the contract. For example, if one party of the contract knows that the other has misunderstood the terms of the contract, he has a duty to inform the other party of the true nature of the contract before entering it. The fourth exception is representation by conduct. This is because conduct, such as a smile or a nod, can be just as misleading as words, as observed in the case of Gordon and Sellico. It should be noted that a conduct may imply certain statements to the other party, which can mislead the other into entering a contract. In such an event, the party which caused such a predicament has an obligation to disclose material facts which could avoid such misassumptions as decided in the Spice Girls case. However, this exception has its fair share of problems. Namely, it can be incredibly difficult to ascertain the meaning behind one's conduct. So, as to not steal the spotlight from our distinguished guests, I would like to ask Ms. Hira, what are the other exceptions of the general rule under the English law of contract? But before we hear from her, to spice things up, let us change our location.
Thank you, Mr. Shaiga. There is a plethora of exceptions to the general rule under English law. In the case of Flanagan, the duty to disclose facts after a change in circumstances was clearly highlighted. Even if a statement of fact is only true at the time it was made, it is the duty of the person to disclose material facts which comes to his notice before the conclusion of the contract, as it falsifies a representation previously made as mentioned under Section 2, Subsection 3 of the Consumer Disclosure and Representation Act. Another exception that comes into play is contracts made between fiduciary relationships. According to Professor Finn, disclosure obligations are determined by reasonable expectations of the parties in a particular relationship. Such a relationship can be defined where there is reliance upon the party in a superior position due to trust and confidence, thus creating expectation of disclosure. Sir Lagat claims that in a fiduciary relationship, one party owes onerous obligation of disclosure to each other. Contracts under Oberma Fide prove to be another exception where there is an obligation of disclosure as these contracts are made under good faith. The principal example of such type of contracts are insurance contracts. Disclosure is imperative while considering insurance contracts that lay widely on utmost good faith. In William and London Insurance Co., Lord Hamilton talks about implied condition in Oberma Fide contracts, in which there is a contractual duty to disclose material facts equally between both parties. Despite the legislative changes in Oberma Fide contracts, such as the 2012 Act and the Insurance Act 2015, the general principle of disclosure are still upheld, where the parties are to take reasonable care to avoid misrepresentation. Furthermore, contracts made under family arrangements are held to adopt a full disclosure policy, as an exception to the general rule as per Greenwood and Greenwood. Additionally, traditionally practiced customs are respected by the English courts, where in Jones and Bowden, the courts held that a full disclosure policy has to be adopted if it has been practiced by the specific trade for a long period of time. Moreover, in certain contracts, there is only a limited duty of disclosure. Examples of such contracts are sales of land, comprises and releases where parties are negotiating contractual compromises of disputed claims, contractual situations where there is a failure to draw attention to the terms of a contractual document, and contracts of suretyship and guarantee, which is often mistaken for Oberma Fide. Duty to disclose can also be imposed by legislation, such as the Consumer Credit Act 1974 and Financial Services and Markets Act 2000.
Ms. Hira, are there any other exceptions to the general rule under the Malaysian law of contract?
As for the Malaysian law of contract, Contract Acts 1915 offer exceptions to the general rule. Firstly, under Section 17b, active concealment of fact can amount to misrepresentation. This is clearly highlighted in illustrations C and D of Section 19, that covers concealment for personal gains on an estate and concealment of intelligence respectively. Application of the aforementioned illustrations can be examined in the case of Tay Thu Bok and Seher Oil, where the defendant actively hid relevant information from the other contracting party, which was held that the act of the defendant amounted to fraud under Section 17 of the 1950 Act. Therefore, there is substantive evidence to deduce that Section 17b implies an exception to the general rule. It is imperative to understand that even though active concealment is an exception in both English and Malaysian jurisdiction, their approach is vastly different, as previously mentioned by Mr. Shahiran. Several exceptions are available under the explanation to Section 17. Yes, the explanation does affirm the general rule which was previously mentioned by Rachel, but while doing so, it also provides two prime exceptions. Firstly, it addresses the boundary question of whether there is a duty for a person to speak. This depends on whether the relationship is more than ordinary. This can be seen by contrasting illustrations of A and B of Section 17 of the 1950 Act. In the former, the relationship is that of a regular buyer and seller which is ordinary, therefore A's silence does not amount to fraud. However, in illustration B, the situation slightly shifts, considering the extraordinary relationship, therefore there is a duty to speak. Extraordinary relationships can be subcategorized under contracts between fiduciary relationships and New Burma FIDE contracts. Both principles have a similar legal standing in Malaysia as it does in English law, therefore there is a duty to disclose material facts while considering such contracts. Its application can be seen in the case of Haji Ahmad Yarkan and Abdul Ghani Khan and others. Second prime exception under the same provision is silence on its own is equivalent to speech in certain circumstances. The general rule does not consider silence as misrepresentation. However, an exception is provided under illustration C of Section 17. In such circumstances, silence does amount to misrepresentation, as the silence here is misleading, as one party requires response from the other contracting party. Failure to respond to the question regarding material facts would constitute as misrepresentation in certain circumstances. Another exception presented under the 1950 Act is provided by the exception to Section 19. At a first glance, it seems that it supports the doctrine of caveat emptor, as mentioned by Rachel. But the key word here is ordinary diligence. What would constitute as the means of considering ordinary diligence would depend on the nature of particular contracts. Therefore, anything extraordinary is an exception as stated in the case of Becca and Tan Chung Kwong. In addition, exceptions to Section 19 does affirm the general rule and the doctrine of caveat emptor, but it is imperative to understand that such provision governs only misrepresentations under Section 18 and silent fraudulent misrepresentations within the meaning of Section 17. So any other fraud under Section 17 is not governed under the exception to Section 19. To conclude, the aforementioned discussion provides various exceptions to the general rule in the Malaysian law of contract as in the English provision.
Thank you, Ms. Hira. And Mr. Nakiran, could you please provide a critical analysis regarding the general rule?
Thank you, Mr. Shahiran. Now, let's focus on the big picture as to critically evaluate the general rule in regards to pre-contractual duty to disclose material facts in both legal regimes. The prime justification for the general rule is that an information acquired by one contracting party would have significant financial value, and a disclosure of such information to the other party would deprive the former unfairly of his profitable information and unjustly enrich the latter. Professor Fried contends such compulsion would create the free rider problem and deter both parties from acquiring valuable information. Furthermore, the general rule can be highly justified as the law of contracts in both regimes is highly governed under the doctrine of rupt individualism, where contractual obligations arise generally voluntarily by parties who deal at arm's length to secure best bargain between them, as expounded by Professor Wadhams. Moreover, Melvin professed that a change in the general rule would open the floodgates. In addition, the general rule should be consistently maintained as to be consistent with other areas of law, particularly the law of tort, which similarly do not impose duty to disclose information as declared in the judgment of Lord Keith. On the contrary, the major argument against the general rule in the English and Malaysian law of contract is it is in contrast to the general duty to negotiate in good faith. Both the aforementioned jurisdictions do not recognize the pre-contractual doctrine of good faith as exemplified in Walford and Miles, where Lord Ackner refused to necessitate doctrine of good faith between parties while negotiating as to preserve the general rule. This is in contrast to many other jurisdictions, namely the American law of contract, where Professor Summers reflect the doctrine of good faith as the greatest advancement in American law. In addition, Article 242 of German BGB, Article 1134 of French Civil Code, Article 1.7 of Unitary Principles, and much more legislations suggest that the general rule in the Malaysian and English law of contract should be reconditioned as to fit the international legal frame. Moreover, Lord Justice Steyn agreed that the common law shaped by the notion of good faith, but the failure to recognize doctrine of good faith leads to irrational choices and unfair trades.
What a fascinating insight, Ms. Mathurin. Could you also possibly add any reforms to both the English and Malaysian positions for the law of contract in regards to the general rule?
Thank you again, Mr. Shahiran. The English and Malaysian law of contract has entered the vicissitudes of legal tensions for past several centuries, but there is always room for reforms as it is not impeccable. In respect for the uniqueness of both regimes, the reforms will be deliberated separately. Primarily, the reforms in English law of contracts can be expounded under three different suggestions. The first suggestion is that the English law should recognize the doctrine to negotiate in good faith as a general principle and place exceptions where it is reasonably aligned with other jurisdictions in the world. Historically, in Carter and Boehm, Lord Mansfield stipulated that duty to disclose information should be recognized for insurance as it is a contract upon speculation. Professor Wem professed that same principle should govern most contracts as most contracts are speculative as it all contains some risk in it. While the Sale of Goods Act 1979 and Consumer Rights Act 2015 protects consumers from the adverse effect of the general rule, it only governs certain subject matters which excludes colossal amount of other affairs to be decided skeptically. Secondly, the English law of contract should incorporate a sophistication scale which takes special knowledge, literacy and language skills of contractual parties into account when determining the reasonable circumstance to necessitate a duty to disclose material facts as to protect both parties in a fair and just manner. Thirdly, the test of materiality in relation to the duty of disclosure employed in the English courts should be replaced by the test of reasonable expectation of disclosure as adopted in the Australian courts. The test can be defined under two propositions. Would the failure of disclosure constitute a misleading or deceptive behavior? Is there a reasonable expectation for such disclosure? Succinctly, these three suggestions could provide a positive impact in the English law of contract if it is being enforced. As for the Malaysian law of contract, there are three suggestions to reform the current general principle as to avoid its repugnant repercussions in addition to the preceding reforms. Firstly, as exception to Section 19 of Contracts Act 1950 provides a strong hold to the general rule, legal jurists have requested to amend the 1950 Act to define what constitutes ordinary diligence as it is very wide as pointed out by Justice Lord Williams. Secondly, the 1950 Act should be further amended to delineate a concise and exhaustive definition of duty of disclosure as both Australia and England did. Such complete definition will be a blueprint for judiciary to refer as to decide the reasonable circumstance of the duty to apply. Unlike the United Kingdom, thirdly, the Malaysian consumer welfare is marginally vulnerable due to the general rule. Regardless of Sale of Goods Act 1957 and Consumer Protection Act 1999, the caveat emptor holds a stronger detrimental foothold in Malaysia than in England. As to prevent such adversity, the proposal of Sodhi Ratchagan to repeal Section 62 of the 1957 Act should be enforced to protect the guarantees under Part 5 of the 1999 Act. These three suggestions should be incorporated in the Malaysian law of contract as to achieve a reasonable balance in our country. Thank you.
Thank you, Mr. Nakiran. However, before we move on to the conclusion, I believe a change of venue is in order. Great ideas, Mr. Nakiran, and I hope that those with the power to change things are listening. And to you, dear viewers, to sum things up, it is clear that the general rule in both the English and Malaysian position states that there is no general duty to disclose material facts, although there are exceptions. Upon further evaluation of such a doctrine, it is clear that there are both positive and negative aspects to it. And to further uphold such a rule whilst maintaining the right to be informed, legal reforms should be taken into account for both legal regimes as we march towards a better future within the legal fraternity, especially in pre-contractual relationships. And to our distinguished guests, thank you so much for coming to our show tonight. And for our audience at home, please tune in next week with a more interesting topic.